Good morning, everyone. Hope you're doing well today. My name is Bahlengoma. I'm a master's student enrolled in the University of Johannesburg, and I'm here to present to you my research titled The Privacy and Legal Implications Regarding the Processing of Honeypot Data. First, I would like to thank my two supervisors, Prof. Noluntu Mpekoa and Dr. Eloise Meyer, for their support and their guidance for the past 2 years, because without them, I don't think I would be here, really. Presentation structured as follows. In the introduction, I'll shortly give a brief introduction about the topic. In the background, I'll provide you the problems that I saw in research. Research methodology, I'll just provide you the aim or the solution to the problems with a number of objectives that I need to address first. Findings and discussions, I'll just talk about them briefly regarding the objectives, and then just conclude the presentation with a summary of the findings. So, as we all know, cyber attacks have been the most aggravating threat an organization has to worry about, has to deal with and prepare for, where hackers enjoy the act of exploiting known and unknown network vulnerabilities in hopes to either disrupt the normal operation of a service system or to find and collect valuable information to either hold it up as ransom, leak it in a digital marketplace on the dark web, or to just dump it online somewhere. So to compensate for this matter, organizations offered a wide variety of highly advanced cybersecurity tools to either mitigate or protect themselves from these cyber attacks. And the one tool that I've been researching, the one that I think is cool, is the Honeypot. So just a brief background with the Honeypot. The first occurrence of such a tool appeared in 1998, where Fred Cohen designed and developed a deception tool whose sole purpose was to trap hackers in it to learn about their motives. It was until 2002 where Lance Spitzner coined that deception tool a honeypot. Lance Spitzner, is the founder of the Honeypot project. And he defined that tool, as a security tool deployed onto a system whose purpose is to lure hackers in it who seek valuable information. So the figures in front of you are different configurations where you could place the honeypot within your system. The first figure is placing it as an external honeypot, so just closer to the external firewall. And then the second one is a honeypot that emulates the configuration of the servers deployed by the organization. So the main advantage to use a honeypot is that it keeps the attention of the hacker away from the real system while it confuses the hacker to interact with it, which in turn allows the honeypot to identify, monitor, and register the actions performed by the intruder and store it in a data log. So the analysis of the data log, reveals crucial information about the attack, the motive behind the attack, which leads to implementing countermeasures to prevent similar attacks in the future, to improve the detection rates of similar malicious activity, and enhance the security of the servers as well as the network operated by the organization. The last two figures are just two other configurations. The first figure is an internal firewall that protects the internal network organized by the organization. Then the last figure is just a grouped configuration of specialized honeypots. So the problem with the honeypot is that it was developed, designed, and already utilized before the legislation of modern privacy laws. In fact, it was never designed to conform, to any existing privacy law at all. The honeypot keeps getting improved, and it's developed to improve the capabilities, to identify the real identity of the attacker and mitigate an intrusion or an attack, without the consideration that the intrusion data is as important to the whole configuration. So there's a limited pool of information that currently exists that offers guides or aids in the collection and utilization of that intrusion data, whilst considering the minimum requirements of any existing privacy law. In fact, I think that there might be an organization somewhere out there that operates a honeypot without knowing that there's sensitive data being collected by that honeypot. For an example, the honeypot can collect an IP address which links to an intruder, so that if If an intrusion, or sorry, if that intrusion data appears in a data breach summary, the liability that the organization will face will be severely high. So ultimately, this research would like to provide a number of sub-objectives that need to be addressed in order to reach the intended solution, which is a set of conceptual guidelines that are specific to modern privacy laws. And the modern privacy laws that I chose for the research was the POPI Act and GDPR, so that we can collect and utilize and process, rather, the intrusion data lawfully. So the sub-objectives are as follows. I need to classify what sensitive data is in order to understand the type of data organizations can collect. Identify the type of data honeypots collect, and then state or differentiate between the laws regarding the honeypot data. So moving on to sub-objective 1, I need to classify what sensitive data is. So it's known as personal information by the POPI Act and personal data by the GDPR. And it's any information belonging to an existing living natural person who is identifiable or identified. So I would like to just briefly explain these three important terms in the definition. So any information is essentially factual and unbiased data regarding the data subject, which could range to their name, their age, current weight and height, all the way to the employment, criminal, and medical history. So even if you inaccurately describe a data subject, whether it be factually misleading or it relates to someone else, it's still sensitive data according to the two privacy laws. But if that information is inaccurate to the extent that it relates to no one, then neither privacy law wants that. The second point is that an existing living natural person, and it's a data subject who's governed and recognized by their respective privacy law. That term is also used to differentiate data relating to a data subject to data relating to an organization. So if the data subject, rather, is alive and well, they're living, their data is fine. But if the data subject is no longer with us, is deceased, their data is not considered at all. Then lastly, identifiable or identified is a way that the privacy law can differentiate between two data subjects, or two or more data subjects, where each data subject has a unique identifier to them. That identifier could be their full name, an ID number, location data, as well as online identifiers. Examples of location and online identifiers could be the IP address, cookie identifiers, as well as a radio frequency identification tag, which belongs to the personal devices that the data subject owns. Moving on to sub-objective 2, identify the type of data honeypots collect. So any data that passes through or travels through the honeypot, it's automatically logged by the honeypot, since it's flagged being part of an intrusion. So that data can be split into two categories, which is information, contents of communication, or information to establish communication. So content of communication is any information that can be exchanged via means of electronic communication that is shareable between a fixed number of parties. So that type of data can either be the message found in an email, full data packets traveling through a network, even digital formatted data such as text or audio messages, images, videos, etc. Whereas information to establish communication or transactional data is any data that can prove that a transaction occurred, and then it can show whether or not that transaction was successful, an electronic transaction rather. So this type of information is needed to identify and outline every single transaction with a unique identifier that happened over the internet. So through honeypot observations, I have identified that transactional data can also be split into its own different categories, which are data required to identify and capture the source of communication, the source and destination of communication, which can be the IP address or the MAC address. Data required to prove the time and date of the intrusion. Data required to identify the communication method used, so that can be your TCP, IP, file transfer protocol, secure shell, etc. And then data required to identify the tools used during the intrusion. So this could be the operating system of the device used by the intruder, or just malware that they use. Then lastly, sub-objective 3. Both privacy laws have a number of legal grounds or legal conditions where the intrusion data, the data that was logged by the honeypot, can be processed. So the first point is consent. So the organization is put in a difficult position since legally they have to ask the data subject for their consent to process their data. However, since the intruder or the attacker has already bypassed the security measures placed by the organization and intruded on the network, they've committed a criminal act which voids or disproves their ability to consent for their data to be processed, which leads to point number 2, that the processing of their sensitive data is needed due to a legal obligation undertaken by the organization. This legal obligation can be a court order or a criminal investigation that's currently being involved. So without this obligation, the organization needs to discuss with the intruder, the attacker, that we've collected your data, the Honeypot logged your data, and we need to process it further in order to identify who you are, which they can't do that. So with this legal obligation, it needs to be done in order to reveal the true identity of the intruder or reveal additional information that can lead to the identity of the intruder or the motive of the intrusion or the attack. The third point, we do know that the intruder has a strong connection with the device that they use during the intrusion, in which that device has its own IP address. So an IP address is a type of transactional data, and it is sensitive, by the way, in which it needs to its purpose, is to capture and trace and identify the source of communication or the source of the intrusion or the attack, which means that this type of information is crucial to identify the intruder, the real identity of the intruder. And then the last point, the GDPR and the POPI Act has a condition in which the collected data needs to be stored for a fixed period of time, which is based on the purpose placed on the honeypot. So the purpose of the honeypot, if the purpose is to safeguard the security of the system, that data needs to be stored for a short period of time or until the attack, the intrusion has been finalized, has been mitigated. But if the purpose of the honeypot is to find the motive of the attack, find the identity of the intruder, it needs to be kept for as long as possible, or unless the organization has other legal grounds to process their data, then it can be kept even longer. So with the aid of the sub-objectives, the research would like to present a solution to the problems that were in hand. So what you're looking at is a high schematic figure of the set of guidelines that I would like to present, which is based on 3 important honeypot operations, which is data collection, data storage, and data analysis. So the point of these guidelines is to aid in processing that intrusion data lawfully in accordance to both the POPI Act and the GDPR. So the first point is data collection. Now, the assumption is that the intrusion has been monitored, it's been identified first, monitored, and now logged. So that data that has been logged in the intrusion is ready to be collected by the security team. So firstly, both laws state that the collection of the data should be for reasons that are specific, explicit, and legitimate, and have a high level of transparency in its use before its further process, which is known as purpose, specification by the POPI Act, and purpose limitation by the GDPR. The data that's being collected needs to be adequate, relevant, and limited to the necessary purposes of the honeypot and the organization, which is known as processing limitation by the POPI Act and data minimization by the GDPR. What that means is that the organization needs to limit the amount of data that needs to be collected. It needs to at this present moment, it needs to relate to the current intrusion. So whatever other data that doesn't relate to the current intrusion, it should be removed or ignored entirely. Also, the data that's being collected must not be modified or altered at all and must regain confidentiality and integrity at all times, which is known as information quality by the POPI Act and integrity and confidentiality as well by the POPI Act, from the GDPR, So the following type of data needs to be considered in order to identify the attacker. And this type of data is sensitive in nature since it relates to the attacker. It identifies the attacker, right? So the type of data to consider when collecting is the source IP address, which is the intruder's IP address that he used during the intrusion. the port number used to connect to the honeypot, timestamps, date, time timestamps, the attack tool, which could be the malware used, session IDs or event IDs that show important events during the intrusion, as well as the tools or the operating system or the device manufacturer used by the intruder. Second point, now that the intrusion data is ready to be collected, it needs to be isolated and retained away from the honeypot so that it can get analyzed. I'll speak about that later. So the collected data needs to be stored after a specific period of time in order to identify the real identity of the intruder. This is known as, it was known as storage limitation by both the POPI Act and the GDPR. In addition, that collected data, before it's being stored, it needs to be accurate and kept up to date at all times. And necessary action needs to be taken if that information is seen as inaccurate or has no purpose in being processed further, which is known as accuracy by the GDPR. Third point is that you need to place necessary security safeguards on the stored data in order to prevent any modifications to it. These security safeguards could be in a format of advanced security or encryption algorithms, rather, placed on the intrusion data in such a way that that data can no longer attribute to the intruder without the use of additional information. This, the encryption algorithms could, the POPI Act calls it de-identification, and then the GDPR calls it pseudonymization. And then lastly, POPI Act and GDPR has additional number of procedures that the organization needs to undertake, which is to ensure that there's ongoing presence or ongoing process of maintaining the confidentiality, integrity, and availability of the stored data, to ensure that there's necessary safeguards placed on the stored data that prevents any loss or damage or unauthorized destruction to the stored data. That said, safeguards should be kept up to date at all times so that the availability and access to the stored data is restored once an intrusion or an incident, rather, appears or occurs. And then the last one is that unlawful, unmoderated, and unauthorized access to the stored data must be prevented at all times, and any foreseeable risks should be identified. So point number 3, after the intrusion data has been collected, isolated, and retained away from the honeypot, it's time to do a detailed examination on that data in order to draw up conclusions about the intrusion. So the GDPR states that the stored data, or the collected data rather, should be analyzed in a lawful, fair, and transparent manner in relation to the intrusion. So clearly, the organization needs to clearly state how the intrusion occurred, what happened during the intrusion, show the important events during the intrusion, as well as the attack tools that occurred during the intrusion, or the attack tools that were collected during the intrusion. So if malware were to be collected in the first stage, the data collection stage, that malware needs to be isolated away from the real systems now in order to avoid any occurrence where the malware could trigger again, where it could just spread across the real system again. And then lastly is that when publishing the analyzed data online, you need to avoid displaying or leaking details pertaining to the network of the organization, where you could use advanced encryption algorithms again, where that data won't relate to the organization. You'll only know that that data belongs to you. No one would know. This will be in case that someone might know and then they will attack you again. So in conclusion, I would like to summarize my findings. The first time with the Honeypot, its intention was to trap hackers in it, and then improved to lure them in it to learn about their motives. Though it was never designed or developed to comply with any modern privacy law. Also, organizations are unaware that sensitive data is involved in there. So in order to tackle that problem, I propose conceptual guidelines to aid in the processing of that sensitive data well, in accordance to the POPI Act and the GDPR. And then the guidelines are based on honeypot operations, 3 important honeypot operations, which was collection, monitoring, and analysis. So with future work, The guidelines are just bare bones. I've used 2 privacy laws. I could expand more with them. If I used others, I'm sure the scope would be different. Maybe implement security measures that highlight that, hey, honeypots do also collect sensitive data. Maybe before the collection of sensitive data, it could be encrypted, and so on and so forth. That concludes my presentation, and thank you.
Thank you very much. Do we have any questions? Thank you. For me, it's something that we just need to think about it, because at the first initiation of an intruder trying to attempt and attack your network, that from their side also it's illegal.
Yeah.
You see. So with regards to most legal act is that there should always be ground for justification in our case, because it's in the interest of the company itself.
Yeah.
So I think with that, just need to maybe review it, and it piqued my interest, because I'm thinking of the honeypot outside your network,
Okay.
and someone keeps on scanning, doing recon and so forth. But then those people, I'm not sure if we need to provide consent for them. So we're looking in the best interest for our company, and also there's justification if they were to institute a legal case against us, because it's our system which is protecting our interests. I think that was my comment. Thank you, and it's really good work.
All
Thanks.
right, no, appreciate it. No, with that, I did highlight it that legally the organization needs to gain consent from the intruder, because they're seen as a data subject. But looking into it, because they've committed a criminal act, their consent has been disproved. I don't think I've highlighted that well, actually. But their consent will be ignored. We won't need it. There's now a legal obligation involved now to find out who that intruder is, since they've now intruded on my network, the organization's network. And then, yeah, we take it from there. All right.